question I was asked to address in this session is, will I be sued for carrying out my patient's wishes? Undoubtedly a timely question, opening, of course, a Pandora's box of debate, and recently topical following Mark Butler's tour of duty, where people showed him the tattoos on their chests with the letters DNR, do not resuscitate. What does that mean? Back to the question. The answer in a nutshell is, no, you will not be sued for carrying out your patient's wishes. However, you may be sued for failing to comply with a properly executed advance care directive. The issue then becomes, what is an advance care directive? What is a valid advance care directive? What constitutes a patient's wishes? What constitutes a substitute decision maker? The issue which arises with an advance care directive is that when you are discussing it, it is important that the patient understands the ramification of their decision-making process. You should say to your patient, you're signing up for something today that's going to happen later. It's going to happen when you don't have capacity to change it. Are you sure that's what you want? Is that how you want to live? And is that how you want to die? The process, however, of a well-constructed advance care directive allows empowerment to the patient and a sense of relief that the decision has been taken out of the hands of the family and the burden is not left to the family to decide, which in many instances becomes a very emotive and subjective issue.
So PCA really supports people having that conversation with their loved ones, making it really clear what you might want at the end of life, appointing a substitute decision maker. But it's not just the conversation, you actually do need to record it. And we know that 82% of Australians haven't actually recorded what they want at the end of life. It's really important that they do record that, and it's important also it's attached to their electronic health record.
As with every legal process, we start off with the common law. The test is that every competent adult has the capacity and the right to refuse treatment. It is what is known as the embodiment of our right to bodily integrity. Invasive treatment without lawful consent equates to trespass. It's simple, it's a strict test. If you invade, you can be held liable for trespass in law. You don't have to show negligence. You don't need to show that the medical fraternity acted in a negligent fashion to prove trespass. You don't have to show, they can't have defence, they can't have mistake as a defence, and you can't raise the defence that non-compliance with an advance care directive was in the best interest and the best course of action. An advance care directive is the embodiment and function of a person's common law right to refuse treatment. It is a document or a verbal request to stop the medical fraternity or allied health from undertaking a procedure. You can't tell the medical profession or allied health what to do, you can just tell them not to do it. An advance care directive is a document prepared today by a competent adult of an expression or wish concerning future health treatment when that person is incompetent in the eyes of the law. Incompetent in the eyes of the law can be due to degradation of mental capacity, unconsciousness, or intoxicating effects of medication. That's a common law interpretation. The statutory schemes interpret competency in a different way. How do we determine who is incapable of making a decision? This will occur when the person is unable to comprehend or retain the information which is material to their decision-making process, and also when the person is unable to use or weigh the information which is being given to them to assess the decision before they make it. Mr A was a patient at a hospital operated by the New England Health Service. On the 19th of August 2008, he signed an advance care directive, which he ticked next to the question, dialysis, I refuse. He placed a tick. On the 1st of July 2009, he was admitted into the emergency unit and transferred to ICU. On the 14th of July 2009, he was put on dialysis and ventilation. Post the 14th of July 2009, the hospital became aware that Mr A had signed an advance care directive, very similar to the example given earlier. The hospital applied to the Supreme Court and sought a declaration to the effect that the Advanced Care Directive was in fact valid and binding, and that the hospital was justified in withdrawing dialysis as soon as it became aware of the Advanced Care Direction in compliance with the wishes of Mr A when he executed the Advanced Care Directive. There were two bits of evidence that were provided to the court: that on the 19th of August 2008, when he executed the document, he was actually competent, and that if they removed him from dialysis, it would hasten his death. The question then to be addressed was simple by the court. Was the execution of the Advanced Care Directive on the 19th of August invalid because at the time he executed the document, he wasn't informed of the risks of refusing dialysis? The court found the following. An Advanced Care Directive made by a capable adult is in a clear and unambiguous fashion to refuse treatment must be respected. If in doubt, yes, apply to the court for an order. Don't make the decision yourself. Until the court determines the decision, the emergency life-saving treatment must be adhered to. So until they made this decision, he had to stay on dialysis. A valid Advanced Care Directive is not dependent on informed consent, and a person is free to refuse treatment on non-medical grounds: religious, social, ethical. My PA is a Jehovah's Witness. She carries an Advanced Care Directive with her all the time. Do not transfuse. However, an Advanced Care Directive may be invalidated where the person is misinformed of risk, different to not having informed consent, and where they have asked about the risks and were not given a reply. The right to refuse life-sustaining treatment does not equate to the right to die. And of course, this raises then the issue of euthanasia and another debate for another day.
I think that Theodora's session on advanced care directives was really quite scary. I mean, what it demonstrated to us was that the legalities are truly complex in terms of ensuring that you have legally documented what you want at end-of-life care. It's different in every state and territory, and if you make an agreement in one state, it won't necessarily be recognised in another.
The position in the ACT is determined by the Medical Treatment Health Directions Queensland, the Powers of Attorney Act 1998. When I navigated my way through this system, in Victoria, an Advanced Care Directive is known as a refusal of treatment certificate. It's determined by the Western Australian Act is called the Guardianship and Administration Act. Here, a person who reaches the age of 18. In the Northern Territory, we have the Natural Death Act, which gives some power to make a direction. It only comes into play again.
Each state you go to has a different set of rules. It's a legal minefield.
Legislation that doesn't talk across state boundaries, a nightmare. An absolute nightmare.
One of the things that comes out of that that's very important is we need nationally consistent legislation around advanced care planning and advanced care directives.
In a nutshell, we have different legislative schemes determining the decision-making process in each state, and we have the overriding common law. The onus is placed on the medical allied health fraternity to adhere to Advanced Care Directive and the role of substitute decision makers, but this can become burdensome and strict on occasion in an already overwhelming practice area where people are dealing with many things on a day-to-day basis. The issue, I think, remains in the detail, and as I say, the devil is in the detail, and we must determine each case on its merits at the time the decision is made to withhold treatment.
Overall, though, I think there's a sensible message. If you want to run an advanced care directive, specify your preferences and make sure you do so in writing, and make sure your family understands what your wishes are, and make sure that the health system understands what your wishes are, and do that ahead of time. If, for example, you start to become demented or you start to become incapacitated from making a decision, it's very difficult then to express your preferences if it isn't written down beforehand and people know what it is. For medical practitioners and nurse practitioners and others on the care team, it's quite important to know what's the law in your particular state. And there are very good digests from the medico-legal people and the law practices about understanding your rights and keeping abreast of the developments in the law.
We still should have some advanced care planning going so that we know in advance what decisions we're going to make before we get to the critical decision making that we have to make in palliative care.
I think it's truly realistic to have a nationally consistent legislation around advanced care directives, and I think we have the opportunity to do it now when we're introducing a national electronic health record. This is the big opportunity. We need to grab it.